What's going on, guys? It's Rodrigo with another episode of Asheville Real Estate News. We have a great episode for you today. If you've been wondering about the eviction moratorium that was passed through by the CDC this past week, we recorded it today, September 3rd. So you're listening to it. We're a couple days past that now, but had the attorney Doug Tate, who's a specialist in landlord-tenant relationship, and we talked about the impact, the ripple effects, things you should be aware about as a landlord, including a $500,000 fine, which blew my mind. But yeah, tune in. You're really going to enjoy this episode. Share it with any of your friends who are a landlord. As always, thank you so much for being here. Thank you so much for tuning in. We'll see you guys on the next one, and hope you enjoyed my conversation with attorney Douglas Tate. Hey guys, welcome back to the show. As I mentioned in the intro, I'm here with Doug Tate, and we're going to be talking a little bit about evictions and kind of just eviction law in general and the moratorium that just got passed through. So, Doug, thank you once again for jumping on so quickly.
Rodrigo, it's my pleasure to be here.
Yeah. So, timeline-wise, that new moratorium came down. Was that like Monday or Tuesday? Like late Monday or early Tuesday is when I saw it. Is that kind of when it went into play?
It was Tuesday, September 1st.
Mm-hmm.
I first saw it on Market Watch.
Yeah.
And I guess the U.S. Treasury Secretary Steve Mnuchin was briefing Congress on it Tuesday afternoon.
Mm-hmm.
And then it was published. Well, it was announced and it was put out to the public on Tuesday. There's a question of when it's going to actually go into effect.
Mm-hmm.
The effective date is the day that it is published with the Federal Registry.
And that has not happened yet?
That's supposed to happen either today or tomorrow.
Okay.
And I haven't seen a notice that it has. But it is pending and impending.
Yeah. And just so obviously, we don't record these live, but today is September 3rd. And so whenever you guys listen to this, that's kind of the time frame that we're working off of. So any conversation we have here is a little bit doing our, well, not me, but Doug's going to do his best to give us insight on something that's not official yet. And a lot of it's probably going to be theory, I'm guessing. But before we even dig into those details, do you mind just kind of letting everybody know your background, how you got here to the, Western North Carolina area, and, anything else that might be relevant?
Well, that really depends on how much time you have. But I've been an attorney for 30 years. I practiced in Raleigh, North Carolina for, about 10 years,
Mm-hmm.
10 or 11 years. And I was missing the mountains. I grew up in the Catskills in upstate New York.
Mm-hmm.
And so in 2000, I moved to Asheville. And I practiced in Asheville doing creditors' rights law, which is landlord-tenant is kind of a subset of that.
Mm-hmm.
And in 2014, I met a great woman who lives in Greenville, South Carolina. And we decided that when we combined households, it would be easier for me to move to Greenville and still practice in Asheville. So my physical office is in Greenville, but I practice exclusively in Western North Carolina. And 3 years ago, I opened my own office, the law office of Douglas J. Tate. And I primarily work with folks who don't meet the criteria to be represented by Pisgah Legal Services,
Mm-hmm.
but at the same time cannot afford market rate legal services. So I do things either on a contingency fee basis, a flat fee basis, or I also have sliding scale rates that, depending on how much income the household brings,
Mm-hmm.
determines my rate, and my rates start at $95 an hour and go up to $195 an hour. So my goal is to be affordable to the average person, so that everyone who wants an attorney can be represented.
Based on that, then it sounds like most of your clients are then renters instead of landlords. Is that an accurate interpretation, or does it go both ways and it just kind of depends?
Actually, it goes both ways.
Yeah. Okay.
For years, I represented exclusively landlords. In the last few years, I've started representing more tenants, but typically, I would say that 80% of my practice is still landlords. And the only tenant cases I really take are the ones that I think are most interesting, and where the landlord has been especially abusive to a tenant.
Gotcha.
And actually, deserves to, actually deserves to have problems.
Deserves to get taught a lesson.
To be taught a lesson. That's a good way of putting it. And so I still represent landlords for the most part.
Okay.
And I come at it from a very business, yet at the same time moral sort of position. I see that, if you're a landlord, you're providing a service that is one of the three basic needs that humans need, being, food, clothing, and shelter.
Yep.
Landlords have a certain obligation in exchange for rent to provide a habitable home, and if they don't, they should have to pay for that. It's along the same lines of when you go to the grocery store and you buy an apple or some other sort of fruit or vegetable, you don't expect it to be laced with DDT, that insecticide that was deemed illegal back in the 1970s. And so, those things are regulated because those things will kill you. Well, the habitability of a home can, whether it's, up to par or not, can kill someone else or somebody as well. And, take mold, for example.
Right.
A landlord that allows their home to be just inundated with mold can cause respiratory problems, and someone who might be susceptible with asthma can actually kill them. So, it's incumbent upon landlords to take care of their properties. But, I come from it from that perspective, and at the same time that it's a business, and landlords need to treat it like a business. They're not running a charity.
Yeah.
And so I would say, so it's basically, you've got to do it right. The statutes say you have to do it right, but also I think there's a moral component. It's a business. And then at the same time, and with one of the groups that you're with, it's an investment. And, you need to take care of your investment. And sometimes that means, replacing the HVAC system when you don't want to. But it's an investment. You have to do it.
Yeah.
And so, those three things, I find it is a lot of fun representing landlords. And, when I've been asked by my friends over at Pisgah Legal, they say, well, you seem like you've got a big heart and you're a nice guy, but you're throwing people out on the street. And I said, I'm not really doing that. I am protecting tenants one landlord at a time, because I want my landlords, the ones that I represent, to do it right. And if they don't, I won't represent them.
Yeah.
But I enjoy landlord tenant law. I think it's a lot of fun, but there are a lot of pitfalls. And if you don't do it right, you just hope you don't get a letter from me.
Yeah, fair enough. No, I think that's what you said is super important. And I know, well, when we buy houses, sometimes you run across people who kind of got into landlording by accident, or they
Oh,
were trying to
sure.
do it as a hobby. And sometimes you have these conversations and you're like, well, what were you thinking? And it's like, there's a very difference when there's somebody who's being a landlord with intention versus by accident, and how they play some things out. And I'm sure you've seen that before a lot. You inherit a house, you move and it's your second home and it can't set, there's a variety of reasons why you can get into the landlording game by accident. It's a tough thing to do accidentally well.
Yeah, no, you're exactly right. And I will tell you that back in the recession of 2008, 9, 10, 11, however far you want to go with it,
Yeah.
I saw a lot of accidental landlords, and they were looking for additional income.
Mm-hmm.
Or, as you said, they inherited that house, but a lot of times it was, I've got that apartment over the garage I've never used, and hey, things are slowing down. Why don't we do that? And
Yeah.
what I saw was, people backing into it and thinking they could do it on the cheap. And I think the reason behind that is most of us have at one time rented, and it looks really, really easy. You pay your rent, when you're the tenant, you pay your rent, you go in and, you live, and, and hopefully you don't have any problems. And for most of us, we don't, or we didn't when we were tenants. And so it looks easy. All you need is a lease, place, and a bank account, to
you're off to the races. Yeah.
Yeah. And you're off to the races. And right there, those three things, are the three things that get most people into trouble. Yeah. Because, they have a place, but they don't know if it meets the code, or the building requirements. They have a lease, which they've either gone to the local office supply store, or they've gone onto the internet and they read something and went, well, yeah, I like that.
That makes sense.
That's good. Yeah. And they don't know whether or not it's not a North Carolina law specific lease. And so it may have in it provisions that don't meet the statutes here. And then they have a bank account, but they don't know, for one thing that I am seeing a lot right now. And I, most of the time when those few times when I'm representing a tenant, I add this in as an affirmative claim or counterclaim, is the whole idea of security deposits. There are far too many landlords out there who don't know the North Carolina Security Deposit Act, and one of the pitfalls, or one of the requirements that can be a pitfall, mm-hmm. is in North Carolina. Yeah, it seems like, okay, sure, we've got to have a separate account for the trust account. That's great. And a lot of folks will do that. But the statute is also very, very clear in that within the original document, or within 30 days of the tenant actually moving into the space, the landlord has to provide the name and the address of the bank where the security deposit is being held. And it is remarkable the number of landlords that don't do that. And, again, they may segregate the funds, they may not, but hopefully they do. But if they do segregate the funds, then they don't tell the tenant where it is. And the penalty for failure to inform the tenant where the funds are being held in the correct amount of time is that at the end of the tenancy, the landlord doesn't get to keep that security deposit, and it automatically goes back. And it does not matter what damages were caused by the tenant. Yeah. Those things that exceed ordinary wear and tear, and that the landlord has to stroke a check and give it right back to him. And it is amazing the number of landlords that don't know that. And in fact, I was talking to a friend of mine who is a lawyer, started, renting property, and he didn't know about it.
Yeah.
For the first 5 or 6 years that he was actually running property. And so, it's just one of those things. You can lose a security deposit, in the blink of an eye for just failing to tell the tenant where it is.
Yeah. Security deposits are interesting. I have moved away from taking security deposits to a certain degree. And I just do.
No, never, ever. No, get your security deposit. You deserve it.
Well, I get that. I just prefer to take like first and second and last month's rent or something like that, because it just seems like security deposits, when I've taken them, have always been the biggest point of contention with tenants. And then you move that out of the equation, and my experience thus far is like, it's almost like we're on the same team. Like there's nothing to fight over anymore. And It's been super positive. And I am curious, and it's just, if you're renting something for $1,000 a month, like $1,000, if they damage the property, yes, it's helpful to have, but it's really not going to be a huge difference to like repair something if it's really an issue.
Well, I find that security deposits are a necessary evil, in that and they're not really evil, but if you do have to jump through hoops with them, but security deposits are absolutely necessary, because at the end of the tenancy, no matter how well you screen a tenant, no matter how how well you think you know them in the very beginning, if you're only collecting rent, and you have that last month's rent, and it's agreed that that's going to be used for their last month's stay, and they come and they turn in the keys, and you go see the place, and you go, oh Lord, this place is a wreck. It's nice to have money that's not yours, sitting in the bank, so that you can take care of some of those things. And so I really do think security deposits are a best practice. I would have them, and because then what you're left, if you don't have one, what you're left with at the end of the tenancy is you're going to have to sue the tenant for damages if you care to get that money back. Get that money that you've had to expend to fix the stove, fix whatever it is, the holes in the wall, that sort of thing. Because if you don't have that, chances are at the end of the tenancy, the tenant is gone. They've moved away or something, or there's just no money in their bank account. And then you got to spend your $100 to go to small claims court to try and get that judgment, and collection on it is
next
very,
very
yeah.
Well,
so for me, my rule is, and whether it's in negotiations or security deposits, is always get your money up front. Get as much as you can, within the bounds of the security deposit statute. And, and then, do it right, put it where it's supposed to be, inform the tenant, and you'll always have it.
Yeah, well, we'll see. Well, you might have just convinced me. I think part of it has just been like,
well, I hope so.
I don't know.
I'm a lawyer. I'm supposed to convince people.
I'm on the fence. We might have to have a follow-up conversation on best practices or something like that. But
okay.
Yeah, well, let's talk about this moratorium. I guess
Sure.
It's kind of an extension of, or a second wave of it, because there was one earlier that came out, I forget when it was, in April-ish, let's call it, kind of at the beginning of the whole COVID situation. And, actually in June, early June, I released an episode on my own talking about what I thought were the unintended consequences of this moratorium. And overwhelmingly, I think it's going to have a very bad effect for tenants in the immediate and in the longer term future. Because if you're a landlord, there's going to be so much more burden of proof on the tenant to prove that they're good tenants, whether that's somebody taking, security deposit first and last month's rent to move in. Mm-hmm. These municipalities are also all struggling. I can't imagine property taxes aren't going to go up at some point in time in the near future, which by the nature of it are going to increase rents as well. So you have this perfect storm brewing where it's like, it might be a short-term fix, but I think we're going to be running into a lot of problems that isn't going to help the people that this is designed for. What's your opinion on it before we even get into like interpreting it, I guess?
Well, let's take the more general, and that is kind of what started back in March, and you're right. The unintended consequence for tenants is, well, okay, so you're not going to be evicted. You know that. And so at the same time, there was, this idea that, well, okay, now I don't have to pay rent. Well, that's all well and good until, the courts came back into session, and now Judgment Day came. Mm-hmm. And it's the same thing I tell landlords just in general, and that is, never let a tenant get more than the current month behind.
Yeah, you never dig yourself out of that hole.
If they can't pay this month, why do you think they're going to be able to pay 2 months, next month? That just doesn't make sense to me. And so really, I thought it was setting up tenants to fail. And, because especially if, people will generally find if they have a little bit of extra money in their pockets, they'll figure out a way to spend it.
Yeah.
And then it's not there for the landlord. And, essentially what we had a backlog of cases. And, when the courts opened back up on June 1st, we had a flood of landlord tenant cases. And we had been watching what the North Carolina Supreme Court Justice, Chief Justice Sherry Beasley's doing as far as opening the courts and trying to make them as safe as possible so that there isn't a spread of COVID. But there was a certain amount of back and forth amongst members of the bar as to whether or not this was a good thing or not. Certainly it seemed on the surface that, okay, yeah, this is great. Tenants will not be evicted and perhaps homeless and therefore stuck in a shelter where, you have close quarters and you're going to have the spread. But, at the same time, if they were getting behind in their rent and not paying their rent, well, again, you're going to have Judgment Day at the end. We also, thought about, well, what is this going to do for landlords? Because landlords have to pay their mortgage every month.
Yeah.
And if they don't have money coming in, and if they're like a lot of the accidental landlords that we're talking about, they don't have a big bank account to, float them more than a month or two, if that. And so this new ruling, which is by the CDC, and so essentially, a product of the Trump administration, is basically saying, okay, there are not going to be any evictions from now until the end of the year. And initially, what was the majority thought was that, well, first of all, the administration or Washington cannot control what is done in state courts. They can deal with those properties that are HUD properties, or where the tenant is getting federal funds through Section 8 to to pay the rent. And that certainly made sense. They funded a lot of this, so the federal government should be able to regulate those things. But that did not apply to just your everyday landlord in Western North Carolina and tenant who is not a Section 8 recipient. And so those evictions have gone forward. This seems to be much more. This is a blanket eviction ban, and there is a question as to whether or not Washington can actually do this. And a lot of us have been trying to figure out, well, can Washington do this? And it seems to be rooted in statutes that have not been used but were written years ago for pandemics. This sort of very thing where the federal government to preserve life throughout the country has the power to do certain things, and so this is apparently what they are relying on. It is also an agency, an executive branch agency, which typically has to go through a rulemaking process. And, rules are made and they're published, and then the public can comment on them. And then from there, they may become law in the sense that it is, an agency rule. Mm-hmm. They've bypassed that as well, stating that this is an emergency circumstance, and the law apparently gives them the opportunity to do that. So. But setting aside the issue of whether or not this actually can be done, it appears that it has been done, and I don't know that anyone will actually challenge it. But it seems to grow out of the August 8th executive orders by President Trump that directed the CDC and the HHS to come up with a decision as to whether or not evictions needed to be stayed. And so this directive has now been answered, and we got the CDC unpublished or announced ruling that will probably be published later today or tomorrow. And the one thing that I want to alert people to is, first of all, this doesn't cover all evictions. It only covers evictions that are caused by the inability of the tenant to pay a monthly rent because they have had a downturn in their economic position,
right,
because of COVID.
So it has to be COVID related in the very beginning. So one of the things that it does right away is it says if you have a tenant who is on a month-to-month lease, or a tenant whose 1-year lease ends in the next 4 months, and the landlord decides not to renew the lease, that's not covered by this stay. Right, because that's not a non-payment issue, right? That's just
it's not a payment issue
or whatever. Yeah. So
yeah, it is absolutely a holdover. And then if the person cannot pay, it again then has to be related to a downturn in their financial status due to COVID. So a loss of a job, a loss of hours, a decrease in pay, those sorts of things. But if for instance, you just lost your job because, I'm going to use an extreme example, because you were dipping into the till and you were embezzling or something like that, you had some sort of criminal behavior. Well, sorry.
Has nothing to do with COVID. Yeah.
It has nothing to do with COVID. And in fact, the rule as basically states that there are circumstances like criminal activity that does not stop someone from being evicted. And so, and the rationale behind this has been exactly what the rationale was for this 3, 4, 5, 6 months ago, and that is, evictions cause homelessness, and whether it's they're going to a shelter or they're living somewhere else outside or couch surfing with friends, that these folks are now going to be living in much closer quarters,
right?
And the spread is more likely. But the stay, again, it has to be COVID related. And one of the things that each tenant has to do to claim this stay is they have to fill out a declaration, which basically states a number of things. The first being that they've tried to pay their rent, they are paying as much as they can in rent, that their downturn was COVID related, that they have exhausted looking for other resources, typically federal government bailout sorts of money, or like Section 8 funds. And so those things, they have to, try to do. And then they also have to acknowledge that, one, that this is not a rent deferment, that it's not a rent exemption. They still have to pay as much as they possibly can during this time, but they just can't. And that all of this rent is going to be due and payable on January 1, 2021.
So, go for it.
Well, and so, and also at the same time, the landlord is allowed to assess late fees for not having the full rent on time. So, and that, when the bill is due and owing on January 1st, if the landlord demands the payment of that money and then they cannot pay it, then an eviction can be started. And, so, you're back into that scenario of, if they can't pay it this week or this month,
they're not going to be able to pay it.
And now you've just accumulated, or you've dug the hole deeper for the tenant.
Yeah.
And at the same time, you've got landlords who, may not be able to make their mortgage payments. And
this could put landlords out of the landlord and get business, right? Like, if you have to go 6 months without receiving rent, that's a pretty big hurdle to overcome.
Oh, absolutely.
I mean, especially if somebody's living in the house and the house is, obviously going to have wear and tear. Like, it's not like it's just bubble wrapped and just sitting there for 6 months, right? Like, you still have taxes, insurance,
exactly.
et cetera. It's a big issue. Let's go back to the beginning of this really quickly from
Sure.
Legal perspective of yours. This seems like a huge overreach from the government, as far as, like, we've had the issue here in the city of Asheville with, like, Airbnbs, right? Like, hey, this is my house. I should be able to do what I feel is appropriate, do what I think is going to benefit me. So that's a whole different conversation, but this seems like an even bigger, like, overreach, and seems like we're setting a really bad precedent for federal government involvement in housing, which, I think there's a really good argument to be made that federal involvement in housing hasn't really produced great results in general, historically speaking.
Well, Rodrigo, you're going to have me on again for another podcast, because that's a whole nother hour.
What's the 1 minute response? Are we in dangerous waters, or do you feel like this has been handled well because of the crazy circumstances? Maybe it's a one or the other. Is that a fair?
I'm not sure I'm really qualified to answer that question, but I will say this. I am concerned anytime the federal government goes beyond its actual mandate either in statutes or by the Constitution.
Right.
That bothers me. At the same time, the federal government, whether it's through the Civil Rights Act or the Americans with Disabilities Act, has been in housing for a long, long time. And in addition, they do subsidize some tenants. Now, have there been a lot of unintended consequences? Oh, absolutely. The whole idea of having, what is now a politically incorrect term to use, but the projects. I mean, that has been, I think universally people have said, no, while it seemed like a good idea on paper, the unintended consequences of concentrating, the poor in one area, didn't achieve the results expected outcome of bringing people up. And so, I would say that there are good things and there are bad things, and I do know that from some of the things that I've read, that the public housing or the I don't want to say public housing because that's a term of art, but housing advocates, are saying that this is not going far enough for the exact reason why, we were just saying the bill's going to come due in January, and that's going to be a problem for tenants. Some people, as you've just indicated, believe that this is an overreach and the government shouldn't be doing this. And, quite frankly, I don't know what the answer is. I'm just trying to figure out, how it works so I can advise my clients.
Fair enough.
And how to use it either to the best of their advantage or how to guard against the worst possible outcomes that a landlord could have. And so, like I said, the whole idea of whether or not this is a good thing or bad thing, either is above my pay grade or it is a discussion that'll take hours.
Well, and the reality is, I mean, to know the answer to that question, it is one of those things that time will tell, right? Like I definitely know what my opinion on it is, and I don't think it's a good thing. I think it's a slippery slope that we're standing on. That being said, could be all wrong and there's no unintended consequences and it achieves the desired results, but that's a timing thing. My reservations if that's actually going to happen, but we can get into some tactical advice as well instead of just speculating on what's happening.
Sure. First of all, again, as far as tactical advice, right now, a landlord has to see this as, this stay, as it is currently presented, is a defense to a complaint for eviction. Okay, so that it has got to be affirmatively raised by the defendant, tenant, to say, hey, you can't go forward on this. And so I think in that respect, a landlord would be foolish not to, unless they feel absolutely that they're on great grounds, but they would be absolutely foolish not to contact their attorney. Yeah, because one of the things, and I'm sorry to interrupt, but one of the things that is kind of scary about this stay is that a violation of the stay by an individual landlord, a violation of it could result in a $100,000 fine and 1 year in prison.
Whoa.
Yeah.
Okay, I want to come back to that in a second.
And if you are a corporate landlord, it is $200,000. Or excuse me, no, it's $250,000 and a year in prison. And then, if that's not enough, if you are successful in the eviction, and that person is evicted from from the rental property and then dies as a result of COVID-19, then the fines for an individual goes from $100,000 to $200,000. For a corporate entity, it goes from $250 to $500. And one of the things, and so again, consult your attorney. But but additionally, I'm not quite sure. When does this fine kick in? Does it kick in when you file the complaint, or does it kick in when somehow you got past the magistrate and you got past the judge, and then somebody else turns around on appeal and says, no, this was wrong, and the person's been put out?
Well, I was going to ask you about, so it's, first off, it sounds like the burden of the proof is on the tenant to justify or to show that their inability to pay is directly related to COVID. Is that just like yes, no, that it's burden of proof is on the tenant, on the defendant, as you mentioned? Is that, did I get that correctly? Okay.
It is a defense.
And they have to
and so the burden of proof is on the tenant.
And then they have to write out a declaration, which is basically an affidavit without a notary. Is that kind of the
basically? Yeah.
Okay.
Yeah.
All right. So
now I will say this though. I guess to be fair, the CDC did say that that if you lie in your declaration, and it can be proven that you've lied, you would face the penalty of perjury.
Okay. Well, compared to 500,000 is risk tolerance there, I guess. So I have a question. You mentioned it's like, if you win an eviction and you go in front of the judge, how is it the landlord's responsibility? Like, how can you get fined for something that a judge is there to protect you from, in theory, right? Like, aren't they supposed? Isn't that or else? What's the purpose of going to eviction court for this? Because I don't. It just feels like it's impossible to win. Then, right? Like,
here's how I think this wins. How this works practically, and that is, you have a landlord sue a tenant for eviction. The tenant raises the defense, the landlord wins, and the tenant appeals within the 10 days here in North Carolina, but fails to post a rent bond. And, the rent bond stays the writ of possession or the execution on the judgment for possession. And so the appeal is still there and will still be heard, but the tenant is now displaced. And then the district court on appeal says, no, this is a stay situation. And then it would be up to someone then, presumably the tenant or tenant's counsel, to, contact the authorities and say, hey, this is a $100,000 fine. And remember, that $100,000 is not going to the tenant; it's going to the federal government.
And is that like? And who? I mean, can you appeal the fine? Like, I mean, do you know? Like, can you go to court and be like, hey, like, judge, like, what else am I supposed to do? Like, I presented my case. I explained why I thought I was right, and you could have said I was wrong. You said I was right. Like, isn't the judge responsible in this too, or the court too? Obviously they get absolved, but still, it seems like tricky.
Well, again, under my scenario, the magistrate, the landlord wins with the magistrate, and then it gets appealed, and the district court judge says, no, you lose. And that's when I think the fine would kick in. And that's really the only scenario where I can see that would happen.
Wow.
And in North Carolina, we have our own statute anyway, where if a tenant is found to have been wrongfully evicted, then the landlord is liable for the damages incurred by the tenant for that wrongful eviction. But again, that generally only comes up when the tenant is not able to post bond. Well, guess what? These tenants are poor. That's the reason, or I don't want to say poor. That's not fair. They are unable to meet their obligations, and therefore, are they going to be able to post a bond?
Probably not.
And so, there is sort of a likelihood that this scenario could take place. But again, it is, it is one of those things where, yes, if you did get fined, there would always be a mechanism for an appeal.
Okay. As long as there's an appeal possibility. Well, let's do this then, Doug.
But I wouldn't count on it. I would not count on being successful in that. But anyway. Yeah.
Well, let's avoid having to appeal it then. It sounds like is the way to go. So 2 questions for you then.
Yeah.
First question. I'm a landlord. I'm renting out a property today. Before I get to it, I just had a question. If there's a property management company, who's responsible? Is it the property management company or the property owner who'd be hit with these fines?
I think it is either the owner or both. And the reason why I say that is, the management company is only an agent of the owner. So, there's an agency issue there. And then you have to look at the contract between the landlord and the management agency. And because most of the contracts that I've seen where management companies, take care of these properties, because they do it for what seems to be a pittance for some of the things that they have to do. They absolve themselves from as much liability as possible.
Right. Okay. I'm a new landlord.
You're a landlord now.
Yeah, so I'm a landlord today. I'm thinking about renting out a property. I just listened to this podcast. I'm feeling really nervous about my exposure. Do you rent a property? Do you not? And if you do, what precautions would you take that I wouldn't have taken before? Or is it business as usual and you just try to be smart?
Well, I wouldn't say do not rent a property. I would say go ahead and rent. Take all of the normal necessary precautions that you would take, but I would not rent on a long-term basis. I would make sure that any lease that I enter today is, and from now until December 31st, or really November 30th, December 1st, is no longer than a month-to-month lease.
That makes so much sense.
Because, they get behind and that's it. You're done. You're not going to renew the term. And so I think that is the safest and cleanest way. Now, in discussions with one of my counterparts who were at Pisgah Legal yesterday, we were discussing this, and he said, Doug, of course, I think you should advise your clients not to enter into long-term leases. It is a, month to month. But also, if they cannot pay, again, because the tenant has to pay as much as they can. And I would say that the landlord should take as much as they can, that once they get to, if they terminate, then they go to court to, on a holdover basis, I would forego the balance that has not been paid. Because our concern is that, well, if the reason why you did not renew the lease was because they were behind in their rent, it seems to me like the reason why you are evicting the person is really because they're not paying all of their rent. And so to be safe and to avoid the penalties we've talked about, it would seem like the safe course would be to, if you get 3/4 of your rent this month and they say that's all they can pay, well then fine. You're going to give your 7 days notice on a month-to-month lease. And, the start of next month, if they're still there, you are going to start your eviction process, but don't ask for the other quarter that you didn't get.
Right. You just
take
waive
what
it.
you can get and get them out. Yeah. Get them out and waive it, get them out and get somebody in there who can pay. Because that's the name of the game in most evictions anyway. If
it's not about recovering the money
behind, you want to get them out and get the next person in who can.
Yeah, evictions. I always says evictions are not about recovering money; it's about recovering the property. And
absolutely, yeah.
I love the month-to-month idea. At least finishing out the year, I guess it's just It's hard to imagine that if the COVID situation is as it is now in January, they're probably just going to extend the moratorium. So we might be in a situation. And again, this goes back to unintended consequences of hurting tenants, where you put them on a month-to-month basis. If that, that seems that's probably going to be the next logical counter by landlords to this decision, then you take away housing security from people, which is just
exactly.
It's crazy.
But let me just say, Rodrigo, real quickly. I mean, you also have the same situation when, think about it. Someone entered into a lease November of last year for 1 year, and now that lease is terminating.
Yeah.
At the end of October. The landlord, needs to look long and hard as to whether or not they allow it to convert to a month-to-month, and then and then B, whether or not if they don't and they have a holdover situation, well, how much money have they lost, and are they willing to risk that in going forward with an eviction? So there are a lot of variables at play, but I think one of the safer things is maybe just depending on the amounts, and if it's a relatively small amount, forget it. Just go on and think about it. We do this all the time in situations where you go to court, you only have posted notice for the tenant to be there, so you don't have personal notice, and the judge looks at you and says, "Do you want to go forward on the eviction?" And at least this was kind of the old days. You had to make a decision: do I waive the rent and go on and get my possession, or do I wait to get service on the person completely? That has changed a bit in the last few years, and now you can bifurcate the actions. But quite frankly, I would, again, if it's a small amount or a negligible amount,
just let it go.
Just get rid of it. Let it go.
Well, Doug, I'm sure there's going to be a lot of people who have questions and may potentially need some counsel in the next few months to navigate what appear to be some pretty choppy waters if you do get into a situation of non-payment of rent because of COVID and figuring out what the best case of action is. So what's the best way to reach out to you, ask you, hire you, et cetera? The best thing to do is call me. My telephone number is 828-230-0850, or you can email me at douglas@tatelaw.net. And, we would be glad to talk to y'all and answer your questions about, these issues, particularly with COVID and as that's going forward. And the other thing I would say is I have, my law office has a Facebook page, the law office of Douglas Tate, and we are putting COVID updates out. As soon as we hear something, I think we had our posts out, midnight Tuesday night after this came out, and so if you want to kind of get the latest or get a feel for what the latest is, check out the Facebook site. Yeah. We'll include all of that in the notes too, so you guys can just go into the notes and click through, and you'll have all of Doug's information in the Facebook page as well.
And one thing I'd like to add is at least as of an hour before we started, I had not seen anything from Chief Justice Sherry Beasley on this issue. And, the North Carolina could push back, it could adopt it. And once it becomes, once Chief Justice Beasley, enters an order for North Carolina, there are no issues as to whether or not there was any government overreach. If she does it and she closes the courts for evictions like she did back in mid-March until June 1, that will be the law of the state. There's not going to be this issue of, did the CDC or President Trump or his administration go too far? Yeah. It will be, that's the way it is here. And, each state will make its own decisions, if at all.
Yeah. Crazy.
So,
crazy.
These are crazy times. And Rodrigo, let me just end with this.
Yeah.
We are all in this together. Chief Justice Beasley, in one of her first orders, indicated that the parties should try to mediate some of these issues. And I would just say that, if you've got a good tenant, a good tenant is a real prize. And, mm-hmm. You know what you've got, and sometimes people do just fall on hard times. And I would see if there is a way to work with the tenant that I hate this phrase because it's such a cliche, but that it is a win-win for both. That the landlord can pay their mortgage and the tenant can be there, and see if you can work a deal that, okay, so maybe you're behind in your rent, but we're going to keep you on. We're going to put a promissory note in place, and you start making incremental payments in January for 6 months. That was part of what the North Carolina rules were, I would just say that is, work with each other as best you can. See what you can do, and try to make this as little of a crisis for everybody.
Yeah, and I'll second that. And we talked about this in March on the show as well. If you do the math, you're going to be better off forgiving somebody's full month of rent if that gives them an opportunity to get back started a month from later. And then you have a tenant that really you're going to have a lot of good loyalty from them. They're going to go the extra mile to make rent payment if they feel that you've gone the extra mile for them. And I've always said, and I think it's a good reminder, is at the end of the day, if you're a landlord, your customer, your clientele is your tenant. And just like in any industry, like you're supposed to do what you can to serve your customer, your client well. And I don't think that's any different. Yes, there's business decisions and obviously don't necessarily always agree with the rules or orders that come through from the government. But if you're in this game as a housing provider, you should focus on providing housing and do it to the best of your ability. For sure.
And again, it's not a charity.
Correct.
But it is a business, and, treat it that way. But also, as we have seen, small acts of kindness from
long way.
Other people in other industries, that's not a bad way to, treat your fellow citizens.
Yeah.
And, because housing is important, and
mm-hmm.
And if I when I lived in Asheville, I was sort of on the front lines of dealing with the panhandling issue and the homelessness issue, and I think there is a common thought that we don't want either one of those, mm-hmm. And if that's true, then as landlords, do your best.
Your part, yeah.
But at the same time, don't be dumb. Yeah. At the end of the day, it is a business, and you've got to look out for yourself, and be careful, but be civil. Mm-hmm. And the best way you can do that is keep the lines of communication with your tenant as open as possible. And I know that tenants, when they get behind, they don't want to talk to anybody. They're embarrassed, they're ashamed, and they think that they're going to get yelled at, and they don't want to feel worse than they already do. And so they just cut off communication, which is the worst thing a tenant can do. Mm-hmm. But try to keep the lines of communication open. And while these folks are not your friends, they are people who fund your bottom line. And if you can talk to them and figure out what's going on, you might be able to come to a better solution than necessarily eviction.
Yeah, no, I think that's great to end on that. Doug, would love to have you on the show. Probably could talk about anything, so that's always exciting. Really enjoyed it, and thank you so much for again. I reached out to Doug. I think it was like yesterday. I was like, "Hey, this just happened. We need to do a show about this." And so again, thanks for being so accommodating so quickly. So,
hey, I'm glad to do it, and if you want to do a follow up in a month, and we can talk about what actually did happen versus what we think was going to happen. I'd be glad to do it.
Okay. Yeah. I'm sure I will take you up on that. And so, thanks. Thank you, Doug. Everybody else, thank you all for tuning in we'll see you guys here next week, and please share this with anybody of your friend or anybody who's a coworker who's got some rental property. Obviously there's a lot of good information in this episode. So take care, and we'll see you all in the next one.